Welcome to Don't IEP Alone, the only podcast dedicated to helping parents navigate the IEP process and hosted by a special education advocate. Your host has been attending IEP meetings for over a decade and has helped thousands of parents go from an IEP rookie to an IEP all-star. Be prepared to learn tips that will be a total game changer for you as a parent advocate and, most importantly, your child's outcomes. Partnered with the award-winning Blog a Day in Our Shoes, you'll be confident, knowledgeable, and actually looking forward to your next IEP meeting. Don't IEP alone. Get ready. Here's your host, from suburban Philadelphia, Lisa Leitner.
Hi, welcome back. This is Lisa Leitner with A Day in Our Shoes and Don't IEP Alone. Thank you so much for tuning in and listening again. If you listened on Tuesday, you heard me chatting with Jennifer Price, who is a special ed attorney from the Pittsburgh area. She is back with me today. Once we finished up that podcast, I said, hey, I have a few more things I'd like to ask you because I know what kinds of questions my listeners and parents always want to ask. So I said, can you stick around and we'll do another recording? And she agreed. So before we get into that, Jennifer has a new book called Empowered. And the ED at the end is in capitals, like for education, get it? It's available as an ebook from Barnes & Noble, and it's available in print and an ebook from Amazon. So take a look at that. Why don't you tell us a little bit about the book before we start our questions today?
Hi, Lisa. Yes, thank you for having me back again. So the book is a book that I consider to be, or like to be considered to be, a playbook for parents and educational advocates helping parents. It goes through cases from 2018, certain specific cases, not all cases, and then provides very specific thought questions at the end that parents can use to analyze their own situation based on how those courts have ruled. So I really wanted to create a book to help parents understand how to use the case law that comes out that we attorneys use on a regular basis.
Great. If you haven't listened already, go back and listen to Tuesday's podcast because we got into much more detail there about some due process hearings and considerations and things like that. But even if you're not considering due process or your situation isn't there yet, I think that this can be a great companion to helping you think through your IEP disputes. Okay, so IEP disputes, one thing I wanted to kind of clarify for parents, and I was telling Jennifer on just a phone conversation that I know a lot of times to my readers and listeners, I tend to be a wet blanket because I give you news or information that you don't necessarily want to hear. But part of my work philosophy and advocacy philosophy is that I have to be realistic with my listeners and readers and tell you what you can expect, because giving you unrealistic expectations as far as resolving issues isn't helpful to anyone. And an area that comes up a lot is the various complaint options that parents have when it comes to, solving or resolving IEP disputes, whether it be, not providing FAPE, not following an IEP, and so on and so forth. So I asked Jennifer if we could spend a little bit of time discussing the various complaint options that are available to parents. Let's start with OCR. And for those of you who don't know what OCR is, it's the Office of Civil Rights. And an Office of Civil Rights complaint is a form, it's an online form. You can go and fill it out. I do have links to it on my website. But I think it's oversimplified in that if you go to the OCR website, you see this form and you're like, oh, cool, form. Let me just fill it out and that's it. My complaint is done. And that's not really how it works, is it?
No. Your complaint is then going to go, through a system to ultimately go to an investigator who will, it's really just the beginning of the process. And it can be the beginning of a long process, quite frankly.
It is. And it's also, I think, important to note that in recent years, and I know people hate me for getting into politics, and I'm not getting into politics, but it's just a fact that in recent years, our Office of Civil Rights has lost a significant amount of funding, particularly in their role in education. And it's been publicly stated by the Secretary of Education and other high-ranking officials that they wish to see OCR have less of a role in public education. So what that means is that they're not going to pay attention to education issues as much as the other issues. There just aren't going to be as many investigators assigned to pursuing those complaints, right?
Yeah, it's going to just trickle all the way down and affect the whole process altogether, which in the end, practically speaking, for parents will create a backlog. So which is why I say it's just the beginning of a long process, because you could file today and because of the lack of funding and the lack of investigators, your case may still, be in the system 6 months, 9 months from now being investigated because they just have so many other cases to handle.
Well, and even if they investigate it, and I had one, I was very new to advocacy when it was filed, or when I was filing it on behalf of a client, and I was working with my supervisor and one of my mentors. It seemed to be pretty much a slam dunk case, or so we thought, because we had smoking guns, and we had lots of them. We had lots of emails, we had texts, we had a lot of really black and white evidence that these particular people were acting in a discriminatory manner. So we filed the OCR complaint, which was quite lengthy. Then the investigator called us, and I love to tell this story because the investigator kept us on. It was literally a 6-hour phone call.
Oh, wow. And
he took a lunch break, we think. We never really got evidence of that, but he put us on hold for like 20 or 30 minutes in the middle of the call. So we're kind of like thinking, is he really just like eating lunch right now? But at the end of that, despite all the evidence that we had, I think it's important for parents to know that the recourse is still very minimal. They ordered, you know what they ordered, staff training.
Yep. Yeah. So, yes. So I've had a conversation with an investigator in OCR before. They will order monetary damages, but it's got to be. They prefer to do it if there's like direct harm. So, the teacher slammed his head into the locker, and then that child went to the hospital and sustained these injuries and these medical bills. So they like to do direct out-of-pocket costs. Whereas if you're filing a lawsuit, you're asking for compensatory and punitive damages to recognize the fact that there may be some direct medical costs or psychiatry costs, but it's just also pain and suffering type, which it can be the compensatory damages part of it, the pain and suffering aspect of it. But yeah, if you go to OCR, they're more training, making sure that the website is inclusive, and then making sure that from a regulatory standpoint that the school complies. So the school then must prove that they are in constant compliance with the federal laws.
Okay, yeah. So I
always ask parents when they come in and they're making allegations of discrimination or whatever the case may be, denial of faith, anything, what is it that you're trying to get at the end of it? If you're making claims of discrimination, are you asking for money damages? Do you want training? Do you want a policy change? What is it that you want in the end? Because then I can better tell you whether you can get that. You're not going to get money damages in a due process hearing. So if that's why you want to claim a denial of faith and follow due process, then that can't be your goal, because you're not going to get money damages.
Right. And I think it's also important to point out that if you do find yourself in due process, particularly in settlement negotiations, the school is going to require that you withdraw any pending complaints that you have, right?
Oh, absolutely, yes. And that includes, because I've had parents to file educator misconduct complaints against superintendents, for instance, and that includes those complaints as well. They want a complete withdrawal of all outstanding complaints. The lawyer calls it a global settlement, meaning everything gets settled, not just the due process hearing. But I will say, because I've spoken directly with the people in the educator misconduct office, if the parent files an educator misconduct complaint and they have done enough of an investigation, or they've read through the complaint and feel that there is enough here to warrant probable cause to do a further investigation, the parent calling or writing an interest to withdraw that complaint does not withdraw the complaint.
Okay.
Because from their standpoint, they've already made a decision that there's enough here, so they're not going to just pull back because the parent wants them to pull back. So I've used that as a form of negotiation, not telling the other side that, but just telling the parent, look, I've already spoken with them. They said that even if you call them and say you're not interested in pursuing it any longer, they're not going to withdraw the complaint. But for purposes of settling this, you still should just agree to do that. And they agree the parents agree to do that, and they actually do that. But from the educator misconduct office, they're not going to just automatically withdraw the complaint.
Okay, that's good to know.
So it's a way to sort of, get what you want from both sides.
Oh, okay. It's also, I think, important to note that much like OCR, at least, Jennifer and I are both in Pennsylvania, opposite ends of the state, but the last I filed a complaint with the state, a professional, it was a misconduct complaint. There are only 2 investigators for the entire state of Pennsylvania.
For the educator misconduct?
Yes, there were at that time.
Oh, wow.
I want to say this was 2012, 2013 is the last time I've done it. But at the time, because we were calling and following up and emailing, and the guy just came out and said, there's only 2 of us. And we have, Pennsylvania has 500 districts and 100 charter schools. So that's, basically 300 apiece that the,
oh my goodness.
So I don't know if that's changed. Again, it was 6 or 7 years ago. But also, and in that one, we happened to I don't want to say prevail because it wasn't a court case, but yes, the state did say, hey, yeah, there is some misconduct here. But again, our recourse was very little, and the person got a public reprimand, which means basically that his name was listed on some obscure website. And if you if you looked for it and Googled the exact term and the guy's full name, yeah, you would find it. But that was really it.
Yes, which is why, because I've had parents say, I want him fired. And I tell them, look, that's the school board decision. You can go forward with this, and the school board can know about all of this and still decide to keep him there. So I don't want you to think that the end result is going to be that office saying you're fired and you have to be replaced, because that's not going to happen. Right.
And yes, and again, it's not trying to be a wet blanket, and I understand as a parent why you have these feelings, but I think you have to be realistic about what you're going to be able to achieve.
Yeah.
So, and in some cases, they're still collecting very large pensions. So, there you go.
Oh yeah, yeah.
So, okay, so let's talk about state complaints a little bit, which we did. So, professional misconduct. Are there any other options?
Not that I can think of, not that I'm aware of. The professional misconduct one, OCR, and then, but I will say that there's also, the Pennsylvania Human Relations Commission, which is, kind of dovetailing with the OCR, but whenever you go in that direction, you're also making a claim of discrimination based on the Human Relations Act in Pennsylvania, and I'm sure they have similar acts in other states.
Okay.
From my personal experience, I would go the OCR route because I think they are more efficient. I had a case that sat for almost 3 years in the Human Relations Commission. After a year, you can decide if you want to file a lawsuit. but the parents were so far in and just had the impression that he was going to wrap it up quickly that they wanted to keep going. And it was 2.5, almost 3 years later, and then he issued a ruling against them. So you could then file, of course, my family could then file in state court because they didn't lose the time since it wasn't an agency. But I prefer OCR. I think they're more efficient. And if my time is going to run out, I don't want it to run out in federal court. I prefer federal court over state court.
Okay.
So if there's going to be one over the other, for my personal preference, I like OCR over the PHRC.
Okay. That's good to know. And it is, since we haven't said it, sometimes we take knowledge, some pieces of knowledge for granted. If you are considering an OCR complaint, you only have 180 days from the last occurrence.
Right.
So that comes up a lot quicker than you'd think when you're thinking, oh, I have 6 months, but you may be 2 or 3 or more months into your dispute when you come upon some evidence. So,
Yeah, and I speak a little bit about discrimination in the book. Not a lot. I think I only talk about 1 or 2 cases. But I do think it's important for parents to know that when you're making claims of discrimination, you have to not only show that the action occurred, but that the school district was on notice of the incident. Because if one thing that I do mention is that the lack of notice is a quick way to a dismissal of the complaint altogether. Because you're holding them, what you're basically saying is that they knew about it and did nothing. So if you can't say that they knew about it because you didn't tell them, your child didn't tell them, however it may be, then that's a fast way to getting it dismissed.
Okay.
And I do remember reading a case where it was a horrible case. Factually, there was a child with Down syndrome who was being physically abused by the special education teacher, and the teacher aide is who witnessed it and told the parent. The parent then, immediately called the police and filed a lawsuit for the actions, claiming also disability discrimination, and the court dismissed it, saying, the school didn't even know about it. As soon as you learned about it, you then filed this complaint when, you have to at least put them on notice of what the issue is and allow them time to sort of correct the situation before we as the court will hold them liable for not doing something.
Okay. So there's no, you should have known better or, that doesn't apply. The could have or should have known or should have known.
Not because what you're trying to prove is that they were deliberately indifferent. And so in order to show that, then you have to show that they knew about it and then did nothing.
Okay, good. That's an excellent piece of advice for parents.
So, and then it's a tough one, right? Because in that situation, the parent would have had to place her child in the same situation and then hope that it doesn't happen again. So it's definitely a tough dynamic.
It is, and that actually comes up a lot. Even if it's not blatant physical abuse, there are a lot of situations that really aggravate a child's condition, and parents really stress over that a lot. Should I send them back? What do I do? We're not having an IEP meeting until next Thursday. What should I do? So it is. It's. But again, I go back to that. Life isn't always fair, and there are no easy solutions, and the schools and the courts and all these agencies don't necessarily feel the same sense of urgency that you do. I understand that you want it to be resolved today so that you can have your child go back to school safely tomorrow, but it just doesn't work that way.
Yeah.
Okay. Well, let's do one more quick topic, and that is just because it comes up a lot in the Facebook group. And I see it as kind of almost like a life preserver or life ring that parents grab onto, and that is FERPA. And first of all, things will come up that some information may be revealed, and all these parents will jump in and say, oh, that's a HIPAA violation, And once we, the other admins and I convince them that, the medical model and educational model are different and that HIPAA doesn't apply here, then it's, file a FERPA complaint. And again, I think that's another option that's there for parents, but it's not going to bring you the level of resolution that most are seeking. Would you not agree?
No, I totally agree. Which is why I don't think that filing a FERPA complaint will get the solution the parents are seeking in a timely fashion. Because in the end, right, if you file a FERPA complaint and they agree, yes, there is a violation here, at most it's going to be training, better training as to how to handle situations similar to that come up. But that resolution may come 3 to 6 months down the road, and there may have been many more FERPA violations in between that time frame. So I think it's best to just, address it immediately, maybe in an IEP meeting or, emailing. I definitely recommend parents emailing everyone. That way there is a record of it all to let everyone know that they're on notice. And I put more than one person on the email. So if you have to do the principal, the special education teacher, or whichever teacher it was, and then there's no response, and you're looking for a response, then just work your way up to the superintendent. But definitely put everyone on notice that this is the problem and you want to meet and you want to make sure it doesn't happen again, because you're going to get the same resolution, but in a more timely fashion.
Okay. So what would, I know what my advice is and has been for 10 years for parents who just really feel like, our kids are just, and you and I see the worst. We don't, no one calls a lawyer because their child's making so much progress, right? I just wanted you to know, things are going so great. They only call us when there's a problem and when it's really, the relationship and the situation is really heading south. And I get that parents want justice and they want fairness and they want resolution and they want things to change for your child. But I've often felt that there truly isn't a lot out there for parents, correct?
No, there's not, which is why you really want to try to arm yourself with as much information as you can. Because I think that there is definitely a power imbalance when it comes to the IEP meetings, and that the teachers receive training. They may, like out here in Pittsburgh Public School District specifically, receives training, or the staff there receive training regularly from their lawyers. It's a very good law firm that at a minimum likes to be able to say they train their teachers on the legal issues and give them case law updates regularly. So there's definitely going to be a knowledge imbalance in the IEP meetings. So I always like for parents to feel, I guess playing off the title of the book, empowered, by just knowing what they know. Because if you know what they know, then you can better either use it to benefit yourself and to your own advantage.
Well, and I think, I think part of it is, fake it till you make it. And even if you don't you want to be empowered, but at the same time, you want to know your limits, because I think when you ask for things or expect things that the school knows that legally they don't ever have to provide, or that legally are never going to go anywhere, I think it makes you look uninformed, and that kind of hurts the balance of power even more.
It does. And I know specifically when we're talking about certain accommodations being made, whether it's maybe a 1-to-1 aid, like I hear that a lot. I want a 1-to-1 aid, and of course the school is like, I don't have the money for a 1-to-1 aid.
Right. I
have one aid for, all 300 kids. Whatever it is that you're asking for, if you can really sit down and articulate the reason, not only why your child needs it, but why their way is not working, it's going to at least get them to listen a little bit more. Because it's definitely got to be structured in a way where their way is not working and it's leading to a denial of faith. Not just because otherwise I think all they're hearing is a parent saying, I want, versus, is this really going to be effective? Because they know at the end of the day, when it comes to a litigation and their due process hearing, what the hearing officer wants to know is, okay, the parent wants this, they're not getting it, but is it leading to a denial of FAPE? Is what you're providing, leading to a denial of FAPE? Even though it may not be the best option, is the child still making meaningful progress? So if the parent can actually show he's not making meaningful progress their way, but if they, offer this, whatever it is the parent wants, then I think they may be able to get a lending year.
That's great. That is really, do you think that schools, I'm always telling parents, you know what, I don't ask why, I don't try to assume intent, I don't try to, you'll make yourself crazy trying to figure out why people do things. I just focus on the facts and getting to my end result with my child or my client. Do you think that schools think that they are providing FAPE, or are they just trying to get out of it for the money and trying to get away with not providing FAPE?
I think schools think that whether they're providing FAPE, I don't think they think about it in terms of, are they providing FAPE for all the kids? I think that they look at it from the standpoint of whatever it is we're providing should be good enough. And so it might be FAPE for some kids, and it might not be FAPE for other kids. But even if it's not FAPE, even if we're not meeting FAPE for those kids, what we're giving should be sufficient. So why is anyone complaining?
Okay.
Yeah. I think, an IEP is an individualized education program, but the public school model is built on a sort of one-size-fits-all. So I think there's always going to be some sort of headbutting because those two models are just fundamentally at odds with each other.
Yeah, that's interesting because I long felt that it's about money and they don't have money to provide these services, blah blah blah. But I mean, lately I'm just seeing more and more evidence with my personal client base of schools spending more money fighting the service than just giving the service.
Yes, I think I read an article. I'm not sure where it was, if it was Philly or Harrisburg, but there was some newspaper article where the person argued the same thing. They went through all of the settlements that the school incurred over special education litigation and made the same conclusion. The school has spent all of this money in legal fees fighting the parents on providing the services when they could have just provided the services from the beginning.
Yeah, it's definitely. It's hard not to get jaded and feel a little despondent at times. It's funny that you mentioned the Pittsburgh district and their training because we have one coming up here. It's an annual event, and our county IU, and our IU is the largest in the state. Every election day, the schools are closed. So every election day, they bring in their very large firm. I'm sure you've heard of them. They cover pretty much a lot of the eastern half of Pennsylvania, and they are school district attorneys. But they hold an in-service workshop on election day all day for IU and all the districts that are served by our IU. And you're right, it just creates this huge imbalance of power. And it also, they pride themselves on saying, we teach you how to write legally sound IEPs. And that's pretty much stating their goal. Like, well, I don't know what they think about FAPE, but hey, the IEP is legally sound.
Right.
So there you go.
Yeah. And that's I think one reason why the schools give pushback because, they're looking at whether what they're doing is legal and the parents are looking at whether it's fair or effective, which can sometimes be at odds with one another. And it doesn't help when you have court decisions or judges in court decisions stating that in the IDEA doesn't guarantee your child a right to, a perfect education or the best education, but just an appropriate education. And sort of what does that mean?
Right. Those vague terms. Well, thank you so much. We are nearing half an hour, so we'll wrap it up. Do you want to give one last plug for your book?
Sure. So my book is entitled Empowered, Using Real Case Examples to Look Deeper into IEP Management. It is available for $12.95 on on Amazon as a paperback or as an ebook, and $9.95 on Barnes and Noble as an ebook.
Okay, great. And I will provide links to both in the podcast directories where I'm listed. It's on iTunes and Spotify and Stitcher and Google Play and pretty much anywhere podcasts are listed, you'll find me. It's Don't IEP Alone. Thank you again, Jennifer Price from Pittsburgh, for being on 2 podcasts. I think that my readers, I'm so used to calling them readers, but I think that my listeners are going to gobble this up and really find it useful. So thank you so much.
Thank you for having me, Lisa.
Thanks for listening to the Don't IEP Alone podcast. No parent should have to IEP alone. And with A Day in Our Shoes, you don't have to. For more IEP assistance and letter templates, visit adayinourshoes.com. For ongoing assistance and support, follow our Facebook page and group.
Me, I could fly up to the sky.
Every day I'm on my road, but today is the day that I meet you, my baby. Hope you're going to stay.
It's gonna be okay, gonna make my day. Go my way, it's gonna be okay, gonna make my day. It's gonna be okay, gonna make my day. Go my way, it's gonna be okay, gonna make my day. Go my way. It's go my way. Go my way. It's go my way. It's go my way.